would happen if the non-citizen showed up to the right time and place in response to the notice of hearing, but the NTA had been incomplete? Would that be grounds for the non-citizen objecting that the entire proceeding was invalid? Because after all, the statute does say, this following information shall be provided. So if the date and time was omitted from the initial one, would that be grounds for an invalidation of the proceeding?
No, Justice Barrett. All of the courts of appeals that have considered that issue and the board, when it has considered that issue, has said that the requirements, both the statutory requirements and the regulatory requirements regarding the notice to appear and the information it has to contain are claims processing rules. They are not jurisdictional rules. So they do not divest the immigration court of jurisdiction if there is information missing from the notice to appear.
So is your position, let me try to state how I don't think you say it quite this way in your brief, but this is what I take from your brief, and I want to see if I'm understanding it correctly. A notice of hearing presupposes that there has been a notice to appear because otherwise, well, both because of the word change, and otherwise there would be no way for the alien to receive it because you have to know what address to send it at or have personally served it, correct?
That's correct.
Okay, so is it your position that once the notice of hearing arrives telling the non-citizen where and when to show up, even if there's some information lacking, and let's say it's information that's even maybe more significant than the date and time that the government has been omitting, and it's maybe an incomplete statement of the grounds for removal, that the alien, by virtue of the in absentia provision, has an obligation to show up because he's on notice. It's not like he's not aware that he is in contact with, immigration and that there are removal proceedings underway. But he has an obligation created by the notice of hearing to show up and at that point to register any objections he may have to the incomplete NTA.
That is our position, Justice Barrett. I want to make sure that I'm clear, though, that we think there are a number of safeguards that would prevent the result that you're talking about or the blank document hypothetical that the other side has raised. And if I could go into those protections. The first is the regulatory requirement that the notice to appear contain the charging information. So if we had a blank document or a document that was missing the charges against the non-citizen,
don't you need the protection from the statute itself? Because the regulatory requirement can be subject to change. So I think your better argument comes from the clear and convincing evidence requirement in the statute itself.
That was my second response, Your Honor, which is we bear the burden by clear and convincing evidence to prove that the non-citizen both received notice and that they are removable as charged. And so if you have a document that lacks charges, we could not prove that the non-citizen actually is removable. And then the third...
I'm sorry.
Well, the third protection I was going to refer to is the fact that in absentia removal is not automatic. There is an immigration judge who is sitting on the other side of the bench and who has to review the documents and decide whether in absentia removal is appropriate. And so I think it is highly unlikely that an immigration judge in the circumstances with the blank document or the document without charges would enter in absentia.
Suppose the A1 notice didn't have the right to counsel in it.
So the answer, I think, is the same as before. We view the right to counsel information obviously as an important piece of information, but the lack of that information does not affect the validity of the proceeding. So if the
right, so it does suggest, you're not informed of your right to counsel. Nonetheless, you have to show up. And I don't see that any of your safeguards actually protect the alien, the non-citizen, in that situation. What's going to prevent the non-citizen from being ordered removed, not being able to reopen, notwithstanding that he's never been told that he has a right to a lawyer?
What prevents that result, Your Honor, is the regulations I was referring to. If the notice to appear does not contain the information about the right to counsel, that is an incomplete notice to appear that would be rejected by the immigration court. I also want to emphasize
Counsel,
that...
let me